The entire intelligence apparatus and law enforcement apparatus within Canada tells the Cabinet and the government that there is no Section 2 CSIS Act threat. Is that right?
No, that is not right. CSIS, and Director Vigneault will be here to speak for himself. CSIS assessed according to their standards under their act. Nobody else was assessing under the standards under the CSIS Act. You asked me, did they tell anybody it had met a standard? They wouldn't use the CSIS Act. That wouldn't be their tool. They would be looking at broader national security issues.
Okay, so what intelligence bureau or agency or law enforcement agency told the government, here's the evidence of reasonable and probable grounds, or reasonable grounds, of a Section 2 CSIS Act threat? And you know, I take it now, because it's advised to you, that that's required to invoke the Emergencies Act. It's in the documents. You were advised of that.
Yes.
Right. So what agency gave you the evidence and the intelligence that said, hey, we have reasonable grounds of a Section 2 CSIS Act threat? There wasn't one, was there?
So let me explain. Nobody bringing advice to the table other than CSIS is assessing that against that threat. Nobody advising the Cabinet. The Cabinet is making that decision. And their interpretation of the law is what governs here and the advice they get. And their decision was, evidently, that the threshold was met.
And I understand that. But you understand that when ministers or administrative agencies, et cetera, are entitled to make a statutory decision, whether or not a statutory requisite is met, they do so based on the evidence that is before them and the submissions before them. You know that.
And indeed, they had a lot of evidence.
Right. And you have the RCMP, you have CSIS, you have the entire intelligence apparatus in the federal government, and none of them said that this threshold was met, did they?
They weren't asked.
Okay.
So,
and with respect to the ministers making the decision, when you're talking about ministers, you're talking about the elected executive, correct?
I am.
All right. So the Prime Minister.
Among others.
Right. To your knowledge, what training in national security and law enforcement does the Prime Minister have?
I couldn't answer that question.
Yeah. Can you agree with me that he doesn't have any, to your knowledge?
I couldn't answer that question. I'm sorry.
All right. And what about Minister Mendicino? He, I understand, has training as a Crown prosecutor at least. Is that right?
That was his former job, yes.
Right. And Minister Blair, he was the chief of police for the Toronto Police Service.
That's correct.
Right. And when did Minister Blair first tell you that he was thinking about invoking the Emergencies Act?
Minister Blair didn't tell me. It came up in discussions at the officials level, and then it came up in discussions at the ministerial level.
There's a record not yet in evidence that states that Minister Blair's strategy was from February 4th on to invoke the Emergencies Act. Were you aware of that?
No.
Again, Deputy Minister Stewart, you've been the Deputy Minister of Public Safety since December of 2019. Is that fair?
Until just recently, yes.
Until just recently. All right. And when you took over that portfolio, I take it that you had familiarized yourself with the process of law enforcement and intelligence agencies with respect to investigations. Is that fair?
Let's say I learned on the job.
You learned on the job, right. And because prior to that, you were with finance, is that correct?
That's correct.
Right. And prior to your appointment into the portfolio of public safety, is it fair to say that other than financial intelligence, that you had not worked in the area of law enforcement or the intelligence field? Is that fair?
Not entirely.
Not entirely?
In the world of finance, there were criminal issues. Right,
exactly. So financial intelligence within the criminal sphere of the Ministry of Finance.
Anti-money laundering, right. Securities crimes. Those
right. And so in your evidence here today already, you've spoken about the thresholds for investigations in your chief, and I want to discuss that for a moment, okay? So you understand, I take it, that law enforcement and intelligence agencies in Canada, the threshold that you're speaking of with respect to opening an investigation, it's referred to in Canada as reasonable suspicion. Are you familiar with that term?
Reasonable grounds to suspect, yes.
Yeah, so there's, and we'll get into that. And you can agree with me that that's a pretty low threshold, is it not, in law enforcement terms?
I would not agree.
Okay. And you're aware that the law recognizes, though, that reasonable suspicion essentially requires more than a mere suspicion, but something less than a belief based on reasonable grounds. Is that your understanding?
I would say it's reasonable grounds to suspect.
Right. And so reasonable grounds to suspect is different than reasonable grounds generally. You understand that, correct?
No.
All right. So you don't know the difference between reasonable grounds and reasonable grounds to suspect.
I don't understand what you're trying
so
to
there's two thresholds in Canada with respect to investigations criminally and in intelligence. We have the lower threshold of reasonable suspicion, which you call reasonable grounds to suspect, and then reasonable grounds, which is also called reasonable and probable grounds. Reasonable probable grounds is a higher threshold than reasonable suspicion. You understand that?
I would have gone the other way.
Pardon me?
I would have put it the other way, so this just shows what I know.
So your understanding is that reasonable suspicion is a higher threshold than reasonable grounds?
If you're going to suspect something, you're going to have a particular act in mind.
Okay. And it's the same thing with reasonable grounds, right? You also have a particular act in mind. Can you agree that reasonable grounds require some reliable information that there is a reason to believe a person or group could have committed an offense or pose a threat to the security of Canada? Can you agree with that?
Yes.
All right. So whereas reasonable suspicion, it just requires a reasonable suspicion, right? It's a lesser threshold than reasonable grounds. Can you agree? And you know that.
I'm a little concerned about getting into a discussion about legal terminology, on which I'm not an expert.
All right. And so can you agree, though, that it is CSIS who is the main agency that administers the CSIS Act?
Yes.
All right. And they're the agency that's primarily responsible for assessing if there's a Section 2 CSIS Act threat to the security of Canada, right?
Yes.
And under Section 12 of the CSIS Act, CSIS is only required to have a reasonable suspicion that there is a Section 2 CSIS Act threat to open an investigation. Is that fair?
Yes.
And they're not required to meet the higher threshold of reasonable grounds to open an investigation.
Do you want to comment?
Well, for Section 12, they would have to get a warrant.
For Section 12, and that's reasonable suspicion. That's what it says.
Again, I'm not an expert when it comes to CSIS, the CSIS Act specifically.
When CSIS gets a warrant, they have to bring a case to a judge, a federal judge.
Right.
So there's going to be more than just reasonable grounds in that case.
Okay, so can I bring up WTS 0000060, please? And can we scroll down to page 5? Okay, and can we scroll down to the heading Intelligence? And just the first paragraph, I'll give you a moment to read that. Now, would you help me with the pronunciation of Minister David's last name? We've all been debating about how to pronounce it properly.
Vigneault.
Vigneault, all right. So David Vigneault, he stated that at no point did the service, being CSIS, assess the protests in Ottawa or elsewhere, those referred to as the Freedom Convoy and related protests and blockades in January and February 2022, constituted a threat to the security of Canada as defined in Section 2 of the CSIS Act, and that CSIS cannot investigate activities constituting lawful protests. And I take it you were advised of this, correct?
Correct.
All right. And can we scroll down then to page 7? And go to the heading Foreign Interference. So Director Veen, you explained that the use of the term foreign influence under Section 2 of the CSIS Act refers to foreign state interference as the term is used within the national security community.
Can you just slow down,
Right.
please?
CSIS assessed there was no indication of foreign state